in this one, it's talking about the UCC and what it does, and it's listing out all the articles. And in this chapter, we're going to look at Articles 2 and 2A, which are sales and leases. But Article 1 has general provisions. Article 3 has negotiable instruments. Article 4 has bank deposits. Article 4A is funds transfers. 5 is letters of credit. 6, bulk transfers and bulk sales. 7 is warehouse receipts, bill of landing, and other documents of title. 8 is investment securities, and 9 is secured transactions. So you can see that it's a very comprehensive set of standards. And it is also a living document. It's something that's continually being revised, and that's very, very helpful, especially in the world that we live in today with all the internet capabilities and digital environment that we're in. So Article 2 of the UCC deals with sales, and a sale is the passing of the title of goods from a seller to a buyer for a price. To be considered a good, the item must be tangible and movable at the time of their identification into a contract. Real estate is not included as a good because it's not movable. However, if I wanted to take the blinds out of a house and then sell them, they would be considered goods because they do not hurt the value of the real estate. Services not covered under Article 2. Services, I'm sorry, are not covered under Article 2. So doctors provide services, lawyers, accountants, tons of services out there. And some people actually provide both a service and sell goods. This is called a mixed sale. So can you guys think of anything right off the top that would be considered a mixed sale?
Massage therapists.
What was that?
Massage therapists.
Massage therapist. Okay. Yeah. If they sell product, right?
Yeah.
The first thing that came to my mind was a mechanic. And that's because a lot of times they're providing a service by working on your vehicle, but they have parts, and they sell those parts to you as well, right? You're paying for the parts and the labor to put the parts on the car or whatever. Another one would be the eye doctor. Obviously, I go to the eye doctor quite regularly. And, so the service part is for the examination, and then I purchase glasses from them. And contacts, although I don't wear those very much anymore. Let's see. So Article 2 does cover mixed sales when the goods are the predominant part of the sale. Article 2A of the UCC deals with leases. Lease transfers the rights of the goods for a set period of time in return for consideration. All leases have a leaser and leasee. However, a finance lease adds a supplier to the lease. Take a look at Exhibit 16.3, which is a finance lease. In my book, page 323. Hair salon, good example, Rihanna. 291 for you guys. So you can see here what I was talking about having a financing lease where you have the bank in there as well. So, so you have your bank here, you have your seller, you have your leaser, you have your seller, and you have your leasee. So in this example that it gives, let's take a look at that. It says Jet Green Airways, a commercial air carrier, decides to lease a new airplane that is manufactured by Boeing. So Boeing is the seller, right? To finance the airplane acquisition, Jet Green goes to Citibank. Citibank purchases the airplane from Boeing, and Citibank then leases the airplane to Jet Green. Boeing is the supplier, Citibank is the leaser, and Jet Green is the leasee. Citibank does not take physical delivery of the airplane. The airplane is delivered to Boeing directly by Jet Green. So you've got your delivery of the airplane, and just take a look at that exhibit and you can kind of see what they're talking about. So the sale is between Citibank and Boeing, and Citibank will give a payment to Boeing for the sale of the airplane. And then Boeing delivers it directly to Jet Green. Then Jet Green pays Citibank the payments on the lease. It's similar to financing a vehicle. If you go to a car dealership and you find a car to lease, you contact the bank to finance the consideration needed for the lease. The leasee is you, the leaser is the bank, and the supplier is the car dealership. Contracts must have an offer and acceptance. We've talked about this a lot in the past. These contracts are no exception to the rule. As long as they show an agreement, the contract can be considered valid. So in other words, when I order something from Amazon and pay for it, I'm making an offer. Amazon then sends me the item, they're accepting the offer, and therefore we've entered into a sales contract in a very basic way. There are some terms of the contract that have been left open. In my contract with Amazon, we have left the shipping arrangements open. So Amazon has the responsibility to find someone to ship the item to me. Other terms that may be left open are price terms, payment terms, delivery terms, time terms, and assortment terms. So why would you want to have open price terms in a contract?
Make bids.
I'm sorry, what was that?
To do like bids like on eBay where they could bid to get the highest seller or highest buyer, I should say.
That's a good example. And what if the market rate for the item, like in this case with eBay, what if it was a fluctuation type of situation? You wouldn't want to lock in a price if, let's say it's going to take 6 months to deliver this or whatever. You wouldn't want to lock in that price until closer to that 6 months so that you can actually have the item for a something that's closer to market value and not market value at the time of getting it as opposed to market value before. The statute of frauds is included in the UCC. Under this provision, sales contracts for goods priced at $500 or more and lease contracts with payments of $1,000 or more must be in writing. Modifications to the contracts must be made in writing to be enforceable. Let's take a look at in my book, it's page 324. It says contemporary environment. It's in the little gray box and it says UCC firm offer rule. So this one says, recall that the common law of contracts allows the offeror to revoke any offer at time prior to its acceptance. The UCC recognizes an exception to this rule, which is called the firm offer rule. This rule states that a merchant who offers to buy, sell, or lease goods and gives a written and signed assurance on a separate form that the offer will be held open and cannot revoke the offer for the time stated for, or if no time is stated, for a reasonable time. The maximum amount of time permitted under this rule is 3 months. So for example, on June 1st, Sophisticated LLC, a BMW automobile dealer, offers to sell BMW M3 Coupe to Mandy for $60,000. Sophisticated LLC signs a written assurance to keep that offer open to Mandy until July 15th. On July 5th, Sophisticated LLC sells the car to another buyer. On July 15th, Mandy tenders $60,000 for the car. Sophisticated is a merchant subject to the firm offer rule. Sophisticated LLC is liable to Mandy for breach of the contract. Thus, if Mandy has to pay $70,000 for the car at another dealership, she can recover $10,000 from Sophisticated LLC. So let's take a look now at the UCC permits additional terms, and that's also in a little block, and it starts on page 325 for me. Okay, so under common laws, mirror image rule, an offeree's acceptance must be on the same terms as the offer. The inclusion of additional terms in the acceptance is considered a counteroffer. We talked about this before as well, rather than acceptance. So if anything is changed in that contract by the offeree before they send it back as an acceptance, then it's actually a counteroffer, and the old contract is now voided and the new contract exists, and the offeree becomes the offerer, and so on. Thus, a counteroffer extinguishes the offerer's original offer. The UCC is more liberal than the mirror image rule. It permits definite and timely expression of acceptance or written confirmation to operate as an acceptance, even though the contract contains terms that are additional to or different from the offered terms, unless the acceptance is expressly conditional on assent to such terms. Just love law. If one or both of the parties to a sales contract are non-merchants, any additional terms are considered proposed additions to the contract. The proposed additions do not constitute a counteroffer or extinguish the original offer. If the offeree's proposed additions are accepted by the original offer, they become part of the contract. If they are not accepted, the sales contract is formed on the basis of the terms in the original offer. For example, a salesperson at Lexus dealership, see car dealerships everywhere in this, offers to sell an automobile to a buyer for $65,000. The buyer replies, "I accept your offer, but I would like to have a satellite radio in the car." The satellite radio is a proposed addition to the contract. If the salesperson agrees, the contract between the parties consists of the same terms of the original offer plus the additional term regarding the satellite radio. If the salesperson rejects the proposed addition, the sales contract consists of the terms of the original offer because the buyer made a definite expression of acceptance. And let's look at one more, the UCC written confirmation rule in my book on page 327. So under the written confirmation rule, thank you, 295, if both parties to an oral sales or lease contract are merchants, the statute of frauds writing requirement can be satisfied if one of the parties to an oral agreement sends a written confirmation of the sale or lease within a reasonable time after the contracting, and number two, if the other merchant does not give written notice of an objection to the contract within 10 days after receiving the confirmation. This situation is true even though the party receiving the original confirmation, the written confirmation, has not signed it. The only stipulations are that the confirmation is sufficient and that the party to whom it was sent had reason to know its contents. So for example, a merchant seller in Chicago orally contracts by telephone to sell goods to a merchant buyer in Phoenix for $100,000. Within a reasonable time after contracting, the seller sends a sufficient written confirmation to the buyer of the agreed upon transaction. The buyer, who has reason to know the contents of the written confirmation, fails to object to the contents of the confirmation in writing within 10 days after receiving it. Under UCC, the statute of frauds has been met, and the buyer cannot thereafter raise it against enforcement of the contract. So, electronic method, I'm sorry, what?
I have a quick question.
Okay.
On the firm offer rules, so if you were to sell the car out from underneath the original purchaser and they go buy a vehicle from another dealership, does that vehicle have to be exactly like the one that they had at the dealership that they were going to sell it to her at? Or if she was to buy a vehicle with more toys on it or whatever, bells and whistles, yeah, would that be included in that difference of what the dealership would have to pay?
So that's a good question. Generally, in these situations, it would have to be a like situation. You know, they would have to be very much the same, the vehicles that they were talking about. So basically, if she got the exact same vehicle, the exact same BMW at another lot, and she paid $70,000, then she could sue for the consideration above what she was originally going to pay. So if, let's say that she got it for $70,000 because it was a superior vehicle, it had more bells and whistles, then that may not be true. And when she goes to sue, she may only be able to, or it may not, you know, let's say that it's got $5,000 more, then she'd only be able to get the $5,000. Does that answer your question?
Okay. Yeah, because I was just thinking, like, when they come out with the specialty vehicles like the Bumblebee and things like that, special Corvettes and stuff that are ordered, and however that may look or work for somebody or not work for somebody,
Yeah.
and what that looks like. So thank you.
And it does depend on, you know, it does depend on your team, your lawyer, and all of that as well, on how that goes. But for it to be fair, a court is going to look at, now let's say this situation is that she can't find a BMW that's exactly like that one. Like you said, maybe it's a specialty vehicle or something, and she can't find one that's exactly like that, and she ends up paying more for a vehicle that's less. Then there might be an argument to get more from that, or however it might be, but that would be up to the lawyers at that point on how much they could actually argue for when it's taken to court.
Okay, thank you.
You're welcome. So we've talked about electronic methods, and we will throughout this whole class, and how the internet has made digital, the digital environment has become such a huge thing for us, and especially now with COVID, and you know, we've kind of been pushed to that digital environment even more. So electronic methods of contracting have been have pushed a revision to the articles, the UCC, and it now covers electronic contracting of sales and lease contracts. And that includes e-signatures, which means a signature on an electronic document is recognized as a lawful signature. E-records, which means a record used for communicating the contract and stored by electronic means. And electronic agent, which is the electronic or automated means for used for the electronic records. Okay, so Article 2 of the UCC establishes precise rules for determining the passage of title. The passage of the title of goods from the seller to the buyer happens by any specified conditions and manner agreed upon by the parties. There are times when the contract does not specifically state how the goods will be transferred. In these cases, the UCC has rules in place to determine the point in time of the transfer of ownership. So a shipment contract requires the seller to ship the goods to the buyer using a common carrier. Title passes to the buyer at the time and place of shipment. In this type of situation, the risk of loss is transferred to the buyer when the seller delivers the goods to the carrier. So if something happens in transit, it's the risk of the buyer and not the seller, because they've already taken possession. The seller they have completed their portion of the contract, their performance on the contract, so it's now up to the buyer. A destination contract requires the seller to deliver the goods to the buyer's place of business unless otherwise specified in the contract. Title passes to the buyer when the goods are delivered to the specified destination. In this type of situation, the seller bears the risk of loss while the goods are in transport. There are situations where the seller would not be required to deliver the goods. For example, let's say that I'm landscaping my yard. I need 25, 30 pound bags of rock for a pond. And I order them online from Home Depot, but I am very impatient and I don't want to wait for shipping, which is true. So I choose to pick them up in the store. When I arrive at the store, they give me a receipt for the rocks and I pick them up. Title transfers to me as soon as I receive the receipt. So this represents the contract. What happens if I'm unloading them into my truck, or if I'm loading them into my truck and 2 of the bags are stolen? Can I go to the store and demand 2 bags?
No, because you've already taken delivery.
I've already taken the risk over as the buyer, and Home Depot has already done their part, or Lowe's, or wherever you go for that. So at that point, the risk was mine. And if they're stolen in that type of a situation, or if I've lost them in that type of a situation, then my recourse would be to go into the store and buy 2 more bags. The risk in these situations where the seller is not required to deliver the goods falls to the buyer when they pick them up or when they receive the contract, depending on if the seller is considered a merchant or non-merchant. So a seller is considered a merchant if they deal in the kind of goods that are involved in the transaction, or their occupation holds that they have knowledge or skills of the goods involved in the transaction. Sorry, I should turn my email off. It's distracting me. So if you think about it, so let's say that I am selling something. Recently I sold a couch, and well, my husband did, and he put it on Facebook Marketplace or whatever, and he sold it that way. So we would be considered in that type of environment, we would be considered non-merchants because we don't generally sell couches. That's not our business. That's not what we do. However, if my husband is an IT guy, he doesn't have a shop, he services, but let's say that he did have a shop and he was selling computer equipment or networking equipment or something. In that case, he would be considered a merchant. Let's take a look at the commonly used shipping terms. This is on page 335 in my book. It says business environment, commonly used shipping terms. Thank you. 303 for most of you out there. So this says often goods subject to a sales contract are shipped by a common carrier, such as a trucking company, a ship, a railroad. Many sales contracts contain shipping terms that have different legal meanings and consequences. The following are commonly used shipping terms. So how many of you have heard of free on board or FOB? Not many. So basically this means that the seller is going to arrange to ship the goods and put the goods in the carrier's possession, and the buyer bears the shipping expense and risk of loss while the goods are in transit. So similar to what we were talking about before. So if a shipment contract specifies FOB, Anchorage, Alaska, and the goods are shipped from New Orleans, Louisiana, the buyer bears the shipping expense and risk of loss while the goods are in transit to Anchorage. FAS is free alongside ship, or FAS vessel port of shipment. So this requires the seller to deliver and tender the goods alongside the named vessel on the dock designated and provided by the buyer. The seller bears the expense and risk of loss until this is done. The buyer bears shipping costs and the risk of loss during transport. So for example, if a contract specifies FAS, the Gargoyle, New Orleans, and the goods are to be shipped to Anchorage, Alaska, the seller bears the expense and risk of loss until it delivers the goods into the hands of the vessel, the Gargoyle, in New Orleans. Once that's done, the buyer passes the shipping costs and the risk of loss passes to the buyer during transport to Anchorage, Alaska. CIF is cost, insurance, and freight. It's a pricing term that means that price is included in the cost of the goods and the costs of insurance and freight. C and F are cost of freight. Free on board, place of destination is requires the seller to bear the expense and risk of loss until the goods are tendered to the buyer at the place of destination. So FOB is probably the most common ones that are on here, and it's FOB, point of shipment, or place of destination. So it would be one or the other. So the first one, point of shipment, then that's the seller is required to get it to the courier, and then place of destination is like what we talked about with the destination portion, where the seller bears the expense and risk all the way to the destination of the goods. Ex-ship is from the carrying vessel, requires the seller to bear the expense and risk of loss until the goods are unloaded from the ship at its port of destination. And no arrival, no sale contract requires the seller to bear the expense and risk of loss of the goods during transportation. However, the seller is under no duty to deliver replacement goods to the buyer because there's no contractual stipulation that the goods will arrive at the appointed destination. So the risk of loss is not always dealt with in the same way. There are specific situations that would require the risk of loss to shift from one party to another. So for example, if the seller delivers non-conforming goods to the buyer has the right to reject them. The risk of loss would remain with the seller until the buyer accepts them or the non-conformity is cured. If the goods are conforming and the buyer refuses them or breaches the contract, the risk of loss would remain with the buyer for a reasonable time. The buyer would only be liable for the loss amount in excess of the insurance recovered by the seller. So how many of you have heard those ads that say, try it free for 100 days or whatever? Probably
Yep.
almost everyone, right? So I just recently bought a bed that was a sale on approval. I received the bed and had it for 100 days to try, and I could return it without any penalty. In this case, the risk of loss would remain with the seller until I, the buyer, keep the bed for more than 100 days. So by keeping it 101 days, I have now said that I feel that it's acceptable and I've accepted the shipment, and now the risk is transferred to me, the sale and the risk. So what about those items that you buy that have a return policy? So for example, if I go into Target and I buy an item of clothing and it says, you can return it up to 30 days or whatever, 60 days or whatever, and I don't return it within that amount of time, obviously, then that would be there. But if I do try to return it, then who do you think bears the risk of loss during that period of time that I have that item with that return policy? Target, yes. And, or no, I'm sorry, the buyer, I would actually, because with these situations, think about it. So if Target if it was similar to that, try it for free for 100 days and Target kept the risk, then what happens if, I lose the item or it's involved in a fire or something like that? The risk of loss would stay with Target until I don't return it, right? So in this case, the risk of loss transfers to the buyer when they take possession. And, you know, it could cause all sorts of issues if it didn't. So in that case, that's what the UCC states, is that in those, if they have a return policy, it still goes to the buyer until, and then if they return it, it goes back to the seller. So who do you think would bear the risk of loss when goods are stolen and resold? So let's think about this. When the item is stolen, the thief doesn't actually receive the title of goods since they obtained something without giving something in return. When the thief sells the item, the buyer does not actually receive the title either, because it was never obtained by the seller, which is the thief. And in these cases, the original owner can come and reclaim the stolen goods. So if they know who it was sold to, they can come and reclaim those stolen goods. The new buyer would be out of money, and the only recourse they have is to sue the thief, the person that sold it to them. So how I watch Pawn Stars. I don't know if you guys do. I've watched several of their episodes. And I always think about them when I get to this part, because in some of their episodes, you'll hear them say that you'll hear them ask them, where did you get this? How did you come by this? Or whatever they say. Where did you get this from? Do you have a certificate of authenticity? Do you have, you know, those kinds of things? Basically, they're confirming that that person owns that item before they buy it, because if they buy it and it was a stolen item, they would be stuck. If the original owner came in and saw that item and could prove that it was theirs, they would get it back, and the pawn shop, or Pawn Stars in this case, would be out that money. So the story about the item that they use in Pawn Stars isn't just for the show, you know, to kind of beef it up and give you more information, but it's also their way of fact checking and making sure that the person actually owns that item before they buy it. So there are situations where a person who obtained goods through fraud, like impersonation or a bounce check, could sell the items to a good faith purchaser for the value, and the title is transferred to that buyer. In this case, the original owner cannot reclaim these items. The title is transferred to the person committing fraud, but the title is considered voidable until it's resold. So if, for example, and we'll talk more about checks later, and some of you may not even know what I'm talking about for bounce checks, but if for example, that I went in and I bought something and I wrote a check for it and my check bounced, which that just the thought of that just gives me heart palpitations, I have to say. But if that happened, then the owner, or the person that I bought it from, the seller, they came to me and they said, you have to give it back because your check bounced. And let's say I said at that point, oh, I've already sold it. Now they have no recourse except for to come after me for the money that I was supposed to give them that didn't go through correctly, right? So, but they can't get that item back from whoever I sold it to, because I made a transaction with that person that was a lawful transaction, and they didn't realize that it was something that could come back to them. So there's always these ifs and buts in law, where you have a situation, but if it has this little bit of a change, then it will be a little bit different. So this is one of those. And so was the try it for free, the sale on approval, as opposed to the return policy sales. You know, they're just a little bit different because of one tiny little thing. And that happens a lot in law. And that's why if you ever get into a situation, any kind of situation, this class is just to bring awareness. And then if you were ever to be in a situation where you needed to sue someone, or you had issues with a certain type of situation, you would go to a legal counsel and you would actually ask them for help. there are just way too many rules and laws. And most of the time, the legal person is going to have to do research because your specific case is going to be something that they're going to have to research and see if they can find enough backup to make the case go. So, so who do you think, let's see, there,
Hey, Cindy.
uh-huh,
I know you said we were going to talk about checks later,
mm-hmm.
future, but would a bouncing check be similar to a declined card, or?
It would, except, and we will be talking about checks later and how that works. And in this day and age, we don't use checks as much. You know, we use our bank card. But it would be similar to your bank card being declined or your credit card being declined. But in a situation of a bounce check, it takes time. And especially if you think back even 10, 15 years ago, people using checks, and this is why a lot of retailers won't even accept checks anymore, is because the process takes some time. And in that time, you've already got the item. And then if that comes back that that's a bad check, or if it bounces, if there's not enough funds, insufficient funds in the account to actually pay that check, then it would, then that seller, that person is out that money. They didn't get that money.
As well as possibly a bounce check fee.
You will, and the buyer, as you know, if I went in and I paid for it and there wasn't enough money in my account to cover it, I most likely, and you still get this from debit cards and stuff too, if you don't have enough money in there, sometimes it will still pay it, it won't decline it, and then you'll get overdraft fees. So, you know, that does still happen to an extent, but at that point, the bank has already said, I'll pay the money for this. Or I won't pay the money for this. So it's pretty much instant now with bank cards, where with a check, it took a few days, and, you know, things could happen. So let's say that, you know, let's say that I had $100 in my account and the item was 50, and I went, let's see, I went out and I bought groceries and they were 75. Now I'm already over it $25, right, in my account. And so by the time things hit, it just depends on where it hits on which one's going to get kicked back. Like I said, that gives me heart palpitations. I can't handle that. But I mean, it has happened in the past, and it happens even today with certain situations where, you know, I've had people come to me and say, I refuse to take checks because I don't want the liability or the risk of having that check. Or, and some of them have even said that they won't deal with anything but cash, which that's a difficult thing in this day and age, because we are very card oriented in this day and age. We use the debit cards mostly, and a lot of us don't even carry cash very often. So, you know, that can cause some issues with certain vendors. And especially, you know, with this pandemic, the preferred method of payment is card, so that there's not a transfer of money. You know, you just go up and you put your card in and you take care of your end, and they don't touch your card, and they're not touching cash that went through all different kinds of people or whatever. So there's like a little bit of a thing going on with cash right now anyway. But yeah, does that answer your question, Jack?
Yeah, it does. Thank you.
You're welcome. Yeah, and we'll definitely be talking about that some more. I think it's the next part, actually. So next week, we'll actually talk about checks and how that works. And we'll get more into that, and you guys will get, you guys that have never dealt with checks before will get to see quite a bit of that information and how that works. Another situation that makes it so that the original owner cannot reclaim the item is the entrustment rule. In this situation, the owner entrusts the item to the merchant who deals in goods of that kind. Now this one gives me heart palpitations too. So the merchant sells the item to a buyer in the ordinary course of business, meaning that the buyer does not know that the sale violates the ownership of another party. So let's take a look at the example. I'll just read it because it's under the entrustment rule if you want to find it. On mine, it's page 340. It says, Kim brings her diamond ring to the ring store to be repaired. Ring store both sells and repairs jewelry. Kim leaves or entrusts her diamond ring to the store as it's repaired. Ring store sells Kim's ring to Harold, who is going to propose marriage to Gretchen. Harold, a buyer in the ordinary course of business, acquires the title to the ring. Kim cannot reclaim her ring from Harold or Gretchen. Her only recourse is to sue the ring store. So that gives me like heart palpitations because I think of, you know, taking my ring in to have it cleaned and they could sell it right out from underneath me, you know? Why would a business not want to do that? They don't want to get sued, first of all.
Yeah.
Oh, sorry, Andrea, go ahead.
I said lawsuits.
Lawsuits, yes. And also, you know, they don't want that stigma. They don't want to be
They lose customers from word of mouth, et cetera, et cetera.
Exactly. So they're not necessarily going to do that, you know, and so you really want to think about it that way. Let's look at case 17-1, state court case entrustment rule, Lindholm versus Brandt on page 341. And I'm going to give you guys a break from my voice for a little bit, and I'm just going to have you guys read through this, and then we'll talk about it a little bit. You did. Rihanna said she heard of something similar happening in a Flagstaff. A store lost a lady's ring. Wow. So lost it or sold it. And thank you, Vanessa. 309 for in my book, it's 341. Oh, good. They found it. That would freak me out.
Bummer.
Yeah, so in this case, the Red Elvis, which is the silk screen on canvas that Andy Warhol created, was in the possession of Lindholm, and Malmberg told Lindholm that he could place the Red Elvis on loan to the Louisiana Museum in Denmark if Lindholm agreed. And instead of placing it with the museum, he sold it to Peter Brandt for $2.9 million. Lindholm had made arrangements to sell Red Elvis to a Japanese buyer for $4.6 million, and then discovered that Malmberg had fraudulently sold it. So the issue here is Brandt a buyer in the ordinary course of business who has a claim of ownership to Red Elvis that is superior to the owner of Lindholm? So because Lindholm entrusted it to Malmberg and Brandt bought it in an ordinary course of business, the courts held that Brandt was the new owner. So yeah.
It seems like if I was the courts, I would say, okay, Brandt, sell it for 4.6 million, recover your 2.9 million, and give the rest to the original owner who really got screwed here.
Right. So, and this is one where law and ethics, right? So you've got law and ethics. So here the question is, did Malmberg act ethically in this case? No, right? I mean, come on. Malmberg took the painting, was supposedly going to put it into a museum and sold it instead. Did he act criminally?
I would say yes.
I would say yes. So in that, law and ethics agrees.
He misled the owner of the painting.
Yes, and they have a letter stating that, because it says by letter dated March 20th, Lindholm agreed and gave permission to Malmberg to obtain possession for putting it in the museum.
Under certain circumstances.
Yes. So does Lindholm have some responsibility to her for the loss of Red Elvis? Yes, absolutely,
Yeah, sure.
right?
Yeah.
I mean, and that's her.
He should at least be able to get that 2.9 million that he sold it for.
Right. So that's her only recourse now, is to sue him. And it does say in here that a court in Sweden convicted Malmberg of criminal fraud and sentenced him to 3 years in prison. A Swedish court awarded Lindholm 4.6 million in damages against Malmberg. Now, whether or not Lindholm was
Too bad he only has some of that.
Right. Whether or not Lindholm was ever able to collect, that's a different story, but something like that. So,
Well, wouldn't they freeze his assets until he was able to pay for that?
so they would definitely freeze his assets, and hopefully there would be enough. So hopefully that 2.9 million wasn't gone already, and some of that was able to come back to Lindholm at that point. But just crazy. And to sell it for 2.9 million when Lindholm could actually get 4.6 for it, that's just crazy too.
Yeah.
But so entrustment is similar to consignment in a way, right? You're giving your item to a person to handle for you, to do something with. But in consignment, the consignor would ask the consignee to sell the item for them, and the consignee would receive a fee for doing so. So how many of you are familiar with consignment?
It happens a lot in antiques, etc.
Yes,
Yeah.
absolutely. The first thing that came to my mind is travel trailers. There's a lot of places that consign travel trailers. And have you guys ever heard of, oh, dang it. No, I've just spaced it. There's a furniture store out there that does consignment too. It's a pretty big one, and I just spaced the name. It starts with an A. Ashley Design, that's what it is. Ashley Design Stores. They're a furniture store and they do consignment. So, you know, there's a lot of places that will take your item and sell it for you and then take a fee from that sale.
I didn't know they did that.
Yeah. There's, sorry, go ahead.
I have a woodworker friend that does that with the shop. So yeah.
Nice.
Oh, that's
Very
cool.
common.
Yeah. Yeah. Consignment it can be very helpful because what do I know about selling something, right? Maybe I don't know anything about it. And like let's just take the case of Ashley Furniture Stores. So they have a showroom. You take your item to them, you let them put it in their showroom, and it gets sold from that showroom under, you know, and people are walking in and out of that. They've already got the client base coming in and out. So I could probably get more for it selling it on consignment than trying to sell it on my own, right? Or I might undervalue it because I don't understand its value or whatever it might be. So basically it's a way for someone to have the marketing and the sales agents and all of that at their disposal without actually having a place to sell it. All right. So chapter 18 deals with sales and leases some more. We're going to talk more about that. It's talking about the contracts in specifically the contracts, and it discusses sellers and leasers and buyers and lessees. And for our discussion right now, I'm just going to use the word seller and buyer and just know that it represents both unless for some reason it specifically pertains to lessees and lessors. So I'll let you know if that happens. But when a seller initiates a contract, there are obligations that are provided in the contract. These obligations may be negotiated, but when the contract is finalized, a breach by either party could lead to a lawsuit. The seller has an obligation to deliver goods to the buyer. Typically, contracts will state specifically where the goods are to be delivered. When they are delivered, the buyer has the option to accept the entire shipment, reject the entire shipment, or reject or accept part of the shipment. Let's take a look at the little box that says sellers and leasers right to cure. And on my book, it's on page 346.
314.
314, thank you. The UCC gives a seller or leaser who delivers non-conforming goods the right to cure the non-conformity, so to make it right. Although the term cure is not defined by the UCC, it generally means an opportunity to repair or replace the defective or non-conforming goods. A cure may be attempted if the time for performance has not expired and the seller or leaser notifies the buyer or leasee of his or her intention to make a conforming delivery within the contract time. So for example, a leasee contracts to lease a BMW 750i automobile from a leaser for delivery on July 1st. On June 15th, the leaser delivers the BMW 550i to the leasee and the leasee rejects it as non-conforming. The leaser has until July 1st to cure the non-conformity by delivering the BMW 750i to the that is specified in the contract. A cure may also be attempted if the seller or leaser had reasonable grounds to believe that the non-conforming delivery would be accepted. The seller or leaser may have a further reasonable time to substitute a conforming tender. For example, a buyer contracts to purchase 500 red dresses from a seller for delivery on July 1st. On July 1st, the seller delivers 100 blue dresses to the buyer. In the past, the buyer has accepted different colored dresses than those ordered. This time, though, the buyer rejects the blue dresses as non-conforming. The seller would have a reasonable time after July 1st to deliver the conforming dresses to the buyer. So how many of you have heard of installment contracts? So an installment contract is a contract that authorizes goods to be delivered in portions at a time. So for example, the seller may have the items delivered in 4 separate deliveries, and each delivery would be considered an installment. You may have seen, well, I guess that's probably
Manufacturing is probably a,
manufacturing, and you're probably talking more about bulk orders. So let's say that you have a seller or a car dealership, and they're going to get 150 cars, and the manufacturing company says, well, look, we don't want to hold up your sales, so what we'll do is we'll ship you 3 installments of 50 cars each, and that way you'll be getting cars as we're producing them. So when we have 50 produced, you'll get the first set, and when we have another 50, you'll get the second set, and then 50 and the third set, right? So that's an example of an installment contract. Each delivery would be considered, in these cases, the full contract can only be rejected if any of the installments substantially impairs the value of the contract. So let's say that delivery number 2 of those cars, 15 cars were not delivered. So it was only 35 cars instead. And 4 of those cars had doors that fall off or whatever. I don't know, something crazy. In that case, they could reject the shipment or reject the contract. So once the contract has been formed and the shipment goes out, which is the duty of the seller in the most cases, the buyer is then ready to perform on their portion of the contract. When the shipment is received, the buyer has the right to inspect the shipment for conformity. The buyer would then accept or reject the shipment. The buyer would then remit payment to the seller. So I always think of, I worked at an office and I had to order a lot of paper. So I always think of our paper supplies coming in, and we would always get these paper supplies, and I would have to count, make sure that they sent the right paper supplies and do all that, and then I would have to sign for it. So it's similar to that. If they didn't send me the right amount of boxes, or if they sent me a different weight of paper or whatever, I could actually reject it and have them send it back. The same thing with like toner, any kind of office stuff like that is what came to my mind. There's a lot of different types of situations, but on a small scale, you could think of it like that. In the case of a breach of contract where the breach is by the buyer, the seller would have remedies that are provided by the UCC. So, for example, if the goods are in the possession of the seller or leaser, they could withhold delivery of the goods. They could resell or release the goods and recover the difference between the contract or lease price and the resale or release price. They could sue for breach of contract and recover as damages the difference between the market price and the contract price. And a lost volume seller can sue and recover lost profits. They can also cancel the contract. Once the goods are in possession of a common carrier, they can stop the goods in transit. And then if the goods are in the possession of the buyer or leasee, they can sue to recover the purchase price or rent, and they can reclaim the goods. So in the case of a breach of contract where the breach is by the seller, the buyer would have remedies that are provided by the UCC. And in that case, if the seller or leaser refuses to deliver the goods or delivers non-conforming goods that the buyer or leasee does not want, the buyer can reject the non-conforming goods. They can cover and recover damage. They can sue for breach of contract and recover damages, and they can cancel the contract. if the seller or tenders non-conforming goods and the buyer accepts them, they can sue for ordinary damages, and they can deduct damages from the unpaid purchase price or rent price. So if the seller refuses to deliver the goods and the buyer wants them, they can sue for specific performance. They can replevy the goods, and they can recover the goods from an insolvent seller or leaser. Let's take a look. Page 352 in my book. It's in the little gray box again. It says buyers and lessees' right to cover. Let's talk about that a little bit. So a buyer or lessee has the right to cover by purchasing or renting substitute goods if the seller or leaser fails to make delivery of the goods or repudiates the contract, or if the buyer or lessee rightfully rejects the goods or justifiably revokes their acceptance. The buyer's or lessee's cover must be made in good faith and without unreasonable delay. If the exact commodity is not available, the buyer or lessee may purchase or lease any commercially reasonable substitute. A buyer or lessee who rightfully covers may sue the seller or leaser to recover as damages the difference between the cost of the cover and the contract price or rent. The buyer or lessee may also recover incidental and consequential damages, less expenses saved, such as delivery costs. For example, university contracts to purchase 1,000 iPads from Orange Store and $300 each for $300 each to be used by its faculty members. Orange Store, because we can't say Apple, breaches the contract and does not deliver the iPads to the university. University covers and contracts with Apple Store to purchase 1,000 iPads at the purchase price of $400 per unit. Here, university may recover $100,000 from Orange Store, which is $400, which is the cover price, minus $300, which is the contract price, times 1,000 iPads. Failure of the buyer or lessee to cover does not bar the buyer from other remedies against the seller. So chapter 19 deals with warranties and product liability. Warranties provide assurance to the buyer that the goods meet a certain quality or certain quality standard. There are two main types of warranties: express and implied. Express warranties are an affirmation that the goods meet the certain standard. Express warranties can be made by accident. There are instances where a seller may brag about the qualities of a good in order to sell it. If the statement is of opinion, it is not an express warranty. The difference can sometimes be difficult to distinguish. For example, here we go again, a car salesperson may say that a car reaches speeds in excess of 100 miles per hour. If that's based on fact, so if the speedometer goes over 100 miles per hour, an express warranty is created. If the same person states that this car is the best deal you will find in town, that statement is based on opinion and does not create an express warranty. Implied warranties are not necessarily stated in a contract, but they are implied by law. There are three common forms of implied warranties: the implied warranty of merchantability, the implied warranty of fitness for human consumption, and the implied warranty of fitness for a particular purpose. Sorry, guys, it's been a long day. So with the implied warranty of merchantability, It's implied by law if the seller or leaser is a merchant. It implies that the goods are fit for the ordinary purposes for which they are used, they are adequately contained, packaged, and labeled, that they are of an even kind, quality, and quantity within each unit. They conform to any promise or affirmation of fact made on the container label. They pass without objection in the trade, and they meet a fair, average, or middle range of quality for fungible goods. In the implied warranty of fitness for human consumption, this is implied by law. It implies that food is fit for human consumption. Each state has adopted one of the following standards, either a foreign substance test or a consumer expectation test. The implied warranty of fitness for a particular purpose is implied by law. It implies that if the goods are fit for the purpose for which the buyer acquires the goods, the seller has reason to know that the particular purpose for which the goods will be used. The seller or leaser makes a statement of the goods that will serve a purpose, and the buyer or leasee relies on the statement and buys or leases the goods. Let's take a look at the ethics case in the gray box that says implied warranty of merchantability. And this is on page 361 in my book.
329.
Thank you. I'm going to give my voice and my tongue a break, and you guys can go ahead and read through this, and then we'll talk about it. All right, so this case is dealing with a Bronco, and Nancy Denny purchased the Bronco. She purchased the Bronco to use as her daily driver. She purchased it to run around town and do all her errands and all that fun stuff. And when she was driving the vehicle on a paved road, she slammed on the brakes in an effort to avoid a deer that had walked directly into the SUV's path, and the Bronco rolled over. So she sued them, and Ford said that the Bronco is intended as an off-road vehicle and not designed to be used as a conventional passenger automobile on paved streets. And Denny was able to show marketing material that promoted it as a suitable to contemporary lifestyles and considered fashionable in some suburban areas. So the trial court found that Ford had violated the implied warranty of merchantability and awarded Denny $1.2 million. The Court of Appeals upheld that. So do you think Ford acted ethically in alleging that the Bronco was sold only as an off-road vehicle?
No.
No. No, because, I mean, if it was only an off-road vehicle, it should be marketed as such, and in this case, it's not. Was the argument persuasive? Obviously not, because they lost. But, there are cases where there are vehicles that are specifically for off-road purposes, and that's all they're for. For example, all the UTVs that are out, all the four-wheelers, all those kinds of things, those are specifically marketed and specifically made for off-road type situations. So in this case, the implied warranty of merchantability was able to help Denny sue for damages. All right. Warranty disclaimers are statements that negate, express, and implied warranties. I've seen a lot of contracts that have disclaimers in them, and that any oral agreements made with terms outside of the written contract will not be honored. Specifically, and I hate to keep coming back to this, but specifically when I'm buying a car. Because when I'm out there with that car dealer, with the seller, with the sales guy or person, salesperson, when I'm out there with that salesperson, generally they're talking that car up so that, I'll buy it. And they may make some certain claims that might imply, it might become an express warranty, right? So to protect them from that, they'll put in the contract that anything verbal is not honored, and only the written contents of the contract are the warranty things for the item. Excuse me.
That's like
So
the one that we read, that story that we read about the guy that bought the truck and it had all sorts of problems. He couldn't
So-
do anything because
they
doesn't
had
matter
said
what they
as
said.
is.
Yep.
Yeah, and we'll talk more about as is in a second too, but yeah, warranty disclaimers are a lot like those disclaimers in the contract. They limit what can be construed as a warranty. So this, the express warranty thing, where it can be made as a mistake, or it can be said and then taken as a mistake, even though it was a mistake, this actually protects them for that. And that leads us into the as is. So the most common disclaimer that I've seen is the as is disclaimer. Most of the time, the as is disclaimer is used on the sale of products. A used vehicle sale would probably use this disclaimer the most, or at least in my experience. So a new vehicle sales use a limited or full as descriptors for their warranties. So limited warranty or full warranty. And they probably have time periods specified in their warranties as well. So full warranty for 3 years or whatever it might be. Or it might just be a limited warranty from the start. They're only going to cover certain things. Let's take a look at case 19.1. In my book, it's on page 364.
332.
Thank you. I'm going to give you guys a few minutes to read this one. Okay, so this is another case where you have sold as is. And in this case, after they bought the vehicle, Roberts obtained a report that stated the vehicle had previously been involved in an accident. And so they sued, saying that they should have let them know that. But because the sellers included sold as is, they prevented Roberts from recovering damages. So do you think Roberts acted ethically in trying to avoid the sold as is clause of the sales contract?
No.
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 But on the other hand, do you think that the dealer should have said, hey, this has been involved in an accident? Or maybe Roberts should have gone home and checked a car or got a Carfax or something
Yeah.
and did his homework, right? So both sides there.
Double edged.
Yeah. So we're going to talk a little bit more about negligence in a little bit, but because it was a used vehicle, so it's already been out there, it's been used, and yes, it could have been a situation where it was dangerous. But because they use that as is, there's not a whole lot of recourse they have. If Roberts were to have been injured, let's say, by the vehicle, then maybe there would have been some sort of, he would have been able to get legal counsel to go after the auto sales place and use it as negligence because they sold him a vehicle that, let's say that the axle fell off of or something, I don't know, something crazy happened and or he rolled it or something like that, then and was injured by it, then that would be something that possibly could bring a negligence case against them, even with that sold as is, just because they have a duty to a duty of care. But again, on the other hand, when you're going to buy a used vehicle, it's very important that you know what you're doing and you check the car over, right, as much as you can. And in certain situations, we've bought used vehicles in the past, and my husband is mechanically inclined, so that's good because he can identify things pretty easily. But we have actually taken it to a mechanic shop and said, you know, what's wrong with this vehicle? Is there anything wrong? Do we need to be concerned? And that was part of our process for buying the vehicle.
In some cases, you can actually take the vehicle overnight. They typically don't do it with used cars, but typically with new cars, you can take it overnight. But I know some dealers will do used cars too.
Yeah, and then you can kind of get an idea and get it checked over by a mechanic or however you need to do it that way. Let's see. So what happens? Well, we just talked about this. What happens when you have a product that's defective and you sustain injuries from it? So manufacturers, sellers, and others have a duty to keep you from injuries from their products, which is what we were just talking about. This is known as product liability. Negligence is when there's been a breach in the duty of care and harm was caused. Strict liability is a tort doctrine that makes everyone in the chain of distribution, liable for the damages caused by the defective product. Let's take a look at Exhibit 19.1 on page, in my book, 367.
335.
Thank you. So you can see how this works. So in a negligence lawsuit, the defendant can only bring the lawsuit against the consumer can only bring the negligent lawsuit against the manufacturer. In a strict liability lawsuit, the consumer can bring everyone in the distribution chain as liable for that. So they can bring their lawsuit against all of them. So the retailer, the distributor, and the manufacturer. There are some defenses that can be used in product liability cases. And some of those are generally known danger. So certain products are inherently dangerous and are known to the general population to be so. And manufacturers and sellers are not strictly liable for failing to warn of generally known dangers. So an example of this is guns. Guns are dangerous. If you buy a gun, you know that a gun is dangerous. There is a defense called the government contractor defense. And that is that if you are a contractor who is building or is manufacturing a product for the in the government specifications, then you're not usually held liable for those types of situations. Abnormal misuse of product. So a manufacturer or seller is relieved of product liability if the plaintiff has abnormally misused the product. So if you're not using it for the purpose it was intended for, then then the manufacturer may have a recourse against your lawsuit. A supervening event is that is like when a consumer purchases a truck and then replaces the tire with large off-road tires that cause the truck to roll over, injuring the driver. In this situation, the seller would no longer be liable. It would be the consumer who actually put different tires on that truck.
It can actually void the warranty too.
It can, yes, it can. So if you have a warranty on your vehicle and you do something to that vehicle to change it, it can void the warranty. So you have to be very careful about that. Assumption of risk. So the doctrine of assumption of risk can be asserted as a defense to product liability action. For this defense to apply, the defendant must prove that, one, the plaintiff knew and appreciated the risk, and two, the plaintiff voluntarily assumed the risk. So a product defect is when there's a defect in the product. There are a bunch of different ways that a product can be found to be defective. Some of the common types of defects are manufacturing, design, and failure to warn. When a manufacturer is making a product, they are responsible for ensuring the quality of that product. If they fail to do this, a manufacturing defect can be found. You'll hear a lot of manufacturers, they have a quality assurance department, and the quality assurance, it's quality controlled or something to that effect. I don't know, some of you might know exactly what I'm talking about and others might not, but when you buy a new item of clothing, sometimes you'll see a little round tag on it and it says QC, and then it's got like a number, and that's who checked the quality of that item of clothing before it was sent out. The number on that would be that person's number, the person that was checking it, the quality control person that was checking it. Sometimes the defect is in the design. So something may happen to injure a person as a result of the design. I know that you guys probably all know something that has been designed specifically to prevent injury. When I think of this, I think of toys for babies and toddlers. They don't have pieces that can be removed because that would be a choking hazard, because babies and toddlers put everything in their mouths, right? So failure to warn is a defect that occurs when a warning is not on a package. So I'm sure you have all seen this. There's a warning on the box. And the thing that comes to mind for me is children's toys again. But it says there's a choking hazard or something like that. And it says warning, choking hazard, or warning, and maybe it has a little voltage sign, and that means that you could get shocked by it. There's also warnings on paint and glue that inhaling them could be toxic, those kinds of things. An example of a manufacturer's defect would be, I could tell you a situation that I was in. So I like to drink Coca-Cola. Sorry, all you Pepsi people out there. And one time I had a can of Coke and I was very thirsty. It was a hot day. I really needed that Coke. It was nice cold Coke. I cracked it open and I started chugging it. And I got probably about halfway through the can and I realized something wasn't quite right. And I looked in the can. I couldn't see anything. My niece was with me at the time and I said, this tastes funny. I don't know. It tastes like metal. And she's like, what? So she took a little sip and I'm so thankful it was just a little sip. And then I went to the sink and poured it out. And when I was pouring it out, I noticed all these little flecks, metal flecks in the can, in the Coke that was coming out. And I also noticed that the can rattled. So what had happened is during manufacturing, some sort of breakdown in a machine or something along those lines had happened. And this can had a piece of metal in it and some metal shavings. And so in that situation, that was a manufacturer's design. The can was sealed. That wasn't something that happened at the store. The can was completely sealed. So that would be considered a manufacturer's design, manufacturer defect. No, Rihanna's asking if there was a recall and what did I do? So there wasn't a recall. That was the only case that I had that there was metal in the can. I did call Coca-Cola corporate and I let them know of the situation. They wanted me to send the can in. There were a couple little things and I was like, this isn't worth it. I just didn't even go any further. I did go to a doctor and I asked them if there would be any issues, you know, before I said that I didn't want to do anything with Coke. I did go to a doctor to make sure there wouldn't be any issues and they said that I should be fine. So I didn't go forward with anything in that situation. But to this day, I don't drink Coke out of a can. It has to be a bottle. I have to see it. I have to be able to see it. It could have, yeah. Now the part never came out. It was just little teeny tiny flecks of metal that went into my body with the Coke. It wasn't actually the part. The part stayed within the can. And I even kept that can for quite some time just in case. So yeah, it was quite an ordeal. And it could have been a lawsuit. I could have sued, which when they asked me for the can, that was part of the reason that I was like, oh, you're not getting the can. You can't have the can. I'll give you the numbers off the can. I'll give you all of that, but you're not getting the can. Just in case there would be some sort of, injury from it.
That was your only evidence and they wanted it.
They wanted it. Yes, they did. I know. So that's what I thought too. And I'm like,
Okay.
yeah. Now, if I had heard that it was happening to other people, that other people were having that same issue, that could have been an issue. That could have been something where I'm like, okay, let's talk about this. Let's, discuss this whole can thing. And now I've got the proof still because I held on to it. There are situations, I'm so sorry about my dogs. There are situations though, where it wouldn't be manufacturer defect. I'm sure you guys, well, maybe not because it's happened quite a while ago, but you may have heard, another one I really like is Forensic Files. And you may have heard of the situation where someone was tainting the Tylenol in the Tylenol bottles. They were going into the store and they were putting stuff in the Tylenol bottles and they actually ended up killing some people. That type of situation would not be manufacturer defect. That would not be a store defect. That was someone that was basically a serial killer in this situation because they went to several different stores and put into the Tylenol bottles stuff. And that's why your Tylenol bottle now has so many safety features. It's got the little foil wrap on it. It's got the well, the cotton inside, and then that's got it's in a box. There's so many different layers to get to inside of it, and that came from that type of a situation where someone was able to tamper. There was another one recently where someone was tampering with, I think it was some dairy product, maybe milk. I don't know. But that got squashed really quickly. Let's look at case 19.2 on page 368 in my book. Oh, maybe? Yeah, there it is. Oh, look, Coca-Cola Bottling Company versus Dolinsky. I'm going to give you guys a couple of minutes to read through this, and then we'll talk about it. Okay, so thank goodness it wasn't a dead mouse in mine. That's disgusting. So this is a similar situation where there was a bottle of squirt in this case instead of Coke, and there was a dead mouse found in it, and in fact feces in it as well, which means that it was in there for a long period of time and before the liquid was put in, because the mouse wouldn't have been able to desiccate after that, right? So desiccate, sorry. So was it ethical for Shoshone to argue that it was not liable to Dolinsky? What do you guys think?
Coca-Cola was definitely liable.
Definitely, right? And could this case have been faked?
No.
Um,
I mean, it could have, but he got sick from it. I don't think you'd put
Not-
a mouse in your own bottle to drink after.
not if there were stains on the can from the feces.
Right. So they determined that this had been that the mouse had been in there for a long period of time, right? And could it be faked? Most likely this situation was not. Just like the part in the little piece of metal in my can wasn't faked. There was no way that would have been able to be faked. But you guys may have heard of the Wendy's case, and where the person put a finger in Wendy's chili, didn't eat it, of course, but they put the finger in Wendy's chili and then sued Wendy's for having a finger in the chili. And they later proved that they were the ones that put the finger there. So there are situations where people where people had actually done that. I was just reading the comments in the chat. So Rihanna, I'm sorry I missed that earlier. The bananas were injected with HIV. That's probably what I was thinking of when I was talking about the milk. It wasn't the milk, it was the bananas. And then Derek said, what do you think of the woman and Gorilla Glue? So that's quite the situation, right? This lady, did you guys all know about this one? Have you seen it?
No.
Yeah, I hadn't heard the story, but I've seen some chatter about it.
So basically this lady had ran out of hair gel for her hair. And so she decided to use Gorilla Glue instead. And so if you get a chance, you can look it up. Just go on Google and just type in Gorilla Glue. I know Gorilla Glue woman or something like that, and it'll come right up for you. But she did talk about a lawsuit. I don't know if she's gonna do a lawsuit, but I'm pretty sure, and I'd have to check it, but I'm pretty sure that Gorilla Glue has warnings on the label that says it's very sticky and
Oh,
it
absolutely.
shouldn't be used on your body. And so anyway, I think that one's just crazy. It's just ridiculous. But anyway,
They're allowed a certain amount of those things.
they are, yes, that's correct. They are allowed a certain amount of unknown substances. However, in this case, Coca-Cola, being such a big manufacturing company, should have quality control. They should have a really good quality control system. And the fact that the can went from probably, so it was manufactured and had to sit for a minute or two because there were, the mouse got in there, it was able to poop in there. And then, so it had been in there for a little bit, even before the liquid was put in. So
Assuming they manufactured their own cans.
Yeah.
Somebody else, they could have bought those.
That's true. That is true. But when you buy that, you would have a duty of care there too, which they could go and sue whoever they bought them from. But they have a duty of care there too, where they would have to make sure that when they take possession of that they've checked it and made sure that it's good, right? They don't want to have that problem later. And actually, this doesn't even say, it says a bottle of Squirt, so it probably wasn't even a can. So the other thing is that he might have been able to see it because Squirt is a light colored drink, but I do believe their bottles are green, huh? So it might be
yellowish, greenish.
Well, anyway, yeah, that's nasty.
Hey, Cindy, I had a question.
Okay.
So just like what you guys were talking about now, let's say I found a droplet, of something in my Coca-Cola can. Could I sue Coca-Cola just for that one droplet, or does it have to be a bunch of evidence to kind of get them?
So when you say droplet, that would be a little difficult just because that would be a liquid in a liquid. But let's say that droplet was a poison substance and you got very sick from it. And when you got sick, they did a lab test and they found that there was poison in that. Then you could definitely bring a lawsuit. Then you were injured by it. So now
it would be something that you couldn't add to the can.
Right. Yeah, exactly. You'd have to be able to prove that poison was in there before you took a drink. So that would be difficult as well because, how are you going to prove that, especially with a liquid? In this case, they were able to prove it with the mouse because, or at least look at the evidence of the mouse. There were brown spots in there. There was feces in there. the mouse had been dead for a very long time. Those kinds of things played into the part that it was something that couldn't have been put in at a later time. Does that answer your question?
Yeah, it does. Yeah, I kind of understand how the having the can with the droplet, you can't really hear it, without having to open it. So I get it.
Right. You wouldn't necessarily know. Now, in my situation where I found a piece of metal in that can, could they argue? Could they have, because I poured all the liquid out. Could they have argued that I put the piece in there?
Sure, if the piece isn't big enough to have not been able to been put in there by you.
Yeah, which in this case, it was in there to where it wouldn't come out the little, when you crack open a can, you've got that little hole. It wouldn't have come out that. So
no evidence of tampering with the can.
Right. And there was no evidence of tamper. So, in my case, it would have been okay, but it could have been a situation where I would have had to, and had I gone forward with it, it would have been a situation where I would have had to approve that had been in there for a long period of time, and that it wasn't me that put it in there. So let's take a look at one more. Let's look at case 19.3 on my book 371. This is state court case failure to warn, Patch versus Hillerich and Bradsby Company.
339.
Thank you. I'll give you a couple minutes to look at this one.
I wonder if this is why they can only use wood bats in certain younger ages of play.
I would assume so.
Yeah.
It still seems kind of, I'm surprised that the plaintiffs got awarded on this.
Yeah.
one.
Yeah. So, I mean, in this case, basically, the bat is, they say the language of the court is the bat is an indispensable part of the game. The risk of harm accompanying the bat's use extends beyond the player who holds the bat in his or her hands. A warning of the bat's risks to only the batter standing at the plate inadequately communicates the potential risk of harm posed by the bat's increased exit speed. H&B is subject to liability to all players in the game, including Brandon, for the physical harm caused by its bat increased exit speed. So they awarded $850,000 in damages. Do you think that H&B should have been found liable in this case?
I really don't think they should have been.
I don't. Yeah.
That's a tough one, right? I mean,
That is.
It is, because I mean, it's an implied thing in that kind of game, like.
Or, yeah.
so like you were saying, do baseball leagues and teams owe an ethical duty to ban the use of aluminum bats?
Sure.
So yeah, I mean, that
Well.
should be up to the team, right? And if they don't ban them, they should warn them, hey, there's risk of injury and you have to wear whatever to, to help.
Are you saying that the company that manufactures the bats liable for that warning, or the teams?
The teams, if they're
I
going to
would think
choose to
so, the
use
teams.
them,
Well, yes.
yeah, that would be my opinion. Because in this case, it just seems like that would just be saying that I would have to warn someone that a bullet kills,
Right.
it comes out of a gun, kills, right? So,
Mhm.
so
I mean,
there
it super sucks for the family. I mean, that's
it
horrible.
does.
But
Oh, absolutely. But also, when you enroll your child in sports, so in any sport, there is a risk of liability. There is a risk there. Um, I have two kids. They're older now, but my youngest daughter was a cheerleader. She was a flyer. She was thrown up into the air. She has a messed up knee.
Oh.
She broke an arm. There are injuries that happen. And, so as a parent, I have to know going into it and putting my child in that there is a risk of injury and death, depending on what happens. I mean, if she would have fell just right and hit her head, same kind of concept. There could have been more issues than just an injury. So,
Cheerleading is a dangerous sport.
cheerleading is very dangerous. And my other daughter was in gymnastics, and she had some, that tumbling. It's crazy stuff. But so she has some injuries from that as well. But nothing like my flyer.
Right.
So yeah, and I mean those are the sports that they chose, but there's other sports out there that are just as dangerous. So you just really have to be careful as a parent putting your child into sports, and you have to be responsible too and say, you know what, I don't want her as a flyer. I could have said that, and they would have, put her as a different person, a different position in the cheer team, but she really wanted to be a flyer. And so, I trusted the team to take care of my child, and that's what happened. So anyway, let's talk about the assignment. So assignment 3 is the end of chapter 19 under the critical legal thinking cases, and for you guys, it is case 19.1. And for everyone that has books like mine, it's 19.5. And this is the design defect, Stay Right Industries, Inc. versus Peterson. So this one talks about the swimming pool, a swimming pool defect.
Does somebody have a page number? I'm not finding it.
So 376 for mine, 343.
343.
Thank
Yeah.
you.
Thank you.
So this assignment is just like all of your others. You'll follow those guidelines that I set for it. I would like to have the legal issue of the case defined, research the case and explain the conclusion, answer the questions that are asked in the case. In this one, there's one question. Is there a design defect? And that's the only question. Give your opinion with two-cited sources, use correct grammar, punctuation, and spelling, and keep your assignment to about 1 page using Times New Roman 12-point font, double-spaced. Are there any questions?
You just said the 1 page, right?
What was that?
Oh, we just have to type the 1 page?
Yeah, just keep it about 1 page. Now, if you cite your sources on the next page, or if it runs over just a tiny bit or whatever, that's okay. But I would like it to stay as close to 1 page as possible. Next week, we will start part 4. We will do part 4, which is chapters 20 through 22. So be ready for that. This assignment is due next Wednesday before class. So at 5:30 p.m. And if there are no more questions, Annalisa says, is a little less than 1 page better than more than 1 page? No, not necessarily. I would like it to stay as close to 1 page as possible, either side, but a little more would probably be better. I just don't want it to be too crazy. Don't get too crazy on me. The reason I'm having you keep it to 1 page is a lot of times in business, business documentation, they want it
Get the most info with the less fucking reading. Oh, excuse me. The most info with the less reading.
That's right. Very good. So, yes. So the most amount of info in the least amount of reading. So basically just, get your information in there, get straight to the point, and get it together. So that's why I'm giving you that 1 page. So if it takes a little bit more, I'm okay. But just try to keep it to about 1 page.
19 pages is a lot to read.
Yes. Yes, it is.
Especially when you work and you teach and you have family and everything else.
Absolutely. So yeah, if there are no more questions, we are done for today, and I'll see you next week at 5:30.
Thank you, Cindy.
Thank you, Cindy.
Have a
Thank
good
you.
weekend.
Thank you.
Tim?